Okay, so let's start. Hello. Hello.
Yes, sir.
Okay, so let's start. Uh, okay, so good evening, everyone. My name is Mithilesh Mahate, and today we are here for the first introductory class on law of torts. Uh, so first in this today's class, we will be discussing about what is law of tort, how is it classified, and its essential ingredients. We will be even discussing a few case laws, and along with that I will be explaining you how to write the answers in your exam and how to respond to questions. Okay, so let's start. Before we start with what exactly is law of torts, it's very important to know the classification of law or the division of law. So as you can see in the screen, it's there. Law is divided into the national and the international law. Obviously, the national law, leaving aside the international parts, the national law is further divided into public and the private sector law. So private laws means relating to individuals or where the rights of the individuals are concerned, while the public law is for everyone, being a citizen of the country, of the nation, the laws that are there to administer the public as a whole. So for examples of public law such as constitution law, administrative law, criminal law, which is applicable for each and everyone in public. Okay, so now next, coming to private law. In private law we have personal laws, law of contract, property law, as well as law of torts. Now, what exactly is law of tort? Before getting into the definition of law of tort, I just want to give you a few basic idea about what tort means. So, the basics of law of torts, as I said. So, as you can see, law of tort is the term. Tort is actually derived from the Latin term tortum, which means twisted or wrong or crooked. So, law of torts is not from India. Like, it is not a codified law. Like for each and every act which we have in India, or each and every law that we have in India, we have a codified law, right? It is codified. You say constitution, there's the Constitution of India. We have the barrack. For criminal law, we have IPC, we have CRPC, we have CPC. But you won't find any codified law with a set of sections, rules, or anything when it comes to law of torts. So how exactly these laws are prescribed? So law of torts is mostly based on the principles of equity, justice, and good conscience. And this law was introduced in India from UK, as we Indians, as the Indian law is mostly based on the UK law. So that's why it was introduced in India from UK only. And in UK, this law was originated with the help of case laws. That's why when we study law of torts, we usually deal with foreign case laws, because this has been coming from UK. Okay, so now what exactly the law of tort is? Like, as I already told you, tortum, it comes from the Latin term tortum, which means an act which is twisted, wrong, or unlawful. So now, coming to the definitions of law of tort. Well, there is no particular or specific definition of law of tort. Various uh, um, experts in the field have given tried to describe or define, give a proper definition to law of tort, and we are going to deal with a few of them, a few ones which we usually come across when we study law of tort. The first one is the definition given by Winfield. According to Winfield, tortious liability arises from the breach of duty primarily affixed by law. The duty is towards persons in general, and its breach is repressible by an action for unliquidated damages. So, what exactly, according to him, law of tort means? See, according to him, the tortious liability or the law of tort comes into play or arises when there is a breach of duty which is affixed by law. That means a duty which is supposed to be fixed by law. For example, let us say we know all our fundamental rights, right? So it is, these are what are fundamental rights? These are the rights which are p- given to us or which we possess by nature of our birth being a citizen of India, right? So these fundamental rights have been enumerated in the Constitution of India. But right now, every individual has his fundamental rights. So, along with the rights that we enjoy, these fundamental rights, we also have a duty to respect the fundamental right of another person. So these the and when we breach this duty, for example, a person is living, our neighbor, we are residing together. X is the neighbor of Y. So what Y does is that Y start in front of the house of X. Y started throwing his garbages, or Y started building his own house, another house in front of the house of X. So here he is breaching the duty, so he is encroaching upon the area of X. So that's where tort comes to play. Again, another, let's take another example, the public roads. Let's suppose we are going on the road, we are going to our colleges, we are on the road, and all of a sudden a car or two three cars come in the middle of the road, they stop in the middle of the road and start playing music in loud noise, making loud noise. So that is where the breach our duty. The road is for public transport, we have the right to passage over that road, and if some other person comes and breaches it, that's where the law of tort comes into play. So that's why the second line, as I said, the duty is towards persons in general, that is the general persons, like the public as a whole, and its breach is repressible by an action for unliquidated damages. That means the breach is supposed to be curbed down by unliquidated damages. Now, what do we mean by unliquidated damages? Anyone? Hello? Hello? Anyone would like to answer? Okay. So damages, there are two types. One is liquidated damages and another one is unliquidated damages. So what exactly are these two types, liquidated and unliquidated damages? So uh, have you guys ever read law of contracts? I'm suppose you have gone through law of contracts. Like, you know that what is a contract and how it happens. Like, there are set of rules and regulations that two parties frame in between themselves. As per common man, I'm talking in layman's language. Contract is between, it may be between two people or three people, but leaving apart that part, two people agree to certain terms and conditions to, and that agreement forms a contract. And in case any of the party to that contract breaches any of the terms and conditions, they already have a prescribed amount or the prescribed compensation for that. That is what we know as liquidated damages, that is, which has been already fixed by the parties to the contract. While unliquidated damages are those damages which are not fixed by any of the parties, because law of tort is not between two parties, it is for the entire public, right? So whoever comes and breaches that, he will be responsible for that. So there is no particular fixed price or fixed damages. Here damages means compensation. It's not that harming or anything, it's about compensation by way of means of money, or it can be through injunction or anything. So unliquidated damages are usually the compensation whose amount are not fixed, it is fixed by the court during hearing. For example, if X commits nuisance in front of Y, then Y can claim compensation from X for causing nuisance. That is law of tort. And while he claims compensation, that compensation amount is not fixed. He can claim any amount, that it is up to the court to grant the amount. So that is why we call it as unliquidated damages, right? So now coming to the Salmon's definition of tort. A tort, according to Salmon, a tort is a civil wrong for which the remedy is action in common law for unliquidated damages, and which is not exclusively a breach of contract or breach of trust or other equitable obligation. So here Salmon says that tort, law of tort is a civil wrong, right? Because here uh, there are two kinds of wrong: a civil wrong or a criminal wrong. And there is a breach of contract, which is also a civil wrong. But there is a difference between breach of contract and law of tort, which I will be explaining later on, subsequently, right now. So now, law of tort is a civil wrong for which the remedy is action in common law for unliquidated damages, as I already explained the unliquidated damages. But a law of tort is not always a breach of contract. The reason behind this is that there are three ingredients which are required in order to constitute law of tort. Those ingredients I will be dealing in the later part. So if those three ingredients are not fulfilled, then it won't be coming under the law of tort, right? So that is the reason it has stated that it is a civil wrong which is not exclusively a breach of contract or breach of trust or other equitable obligations. Now coming to the definition given by Fraser. According to him, tort is an infringement of right in rem of a private individual giving a right of compensation at the suit of the injured party. So before we come to this definition, I want to explain what exactly do we mean by right in rem. So there are two kinds of right, which we know: right in rem and right in personam. See, so right in rem, it corresponds to the duty which is imposed upon persons in general. As I said, law of tort is all about right and rem. It corresponds to a duty imposed upon persons in general. For example, it is a duty of general public not to cause nuisance, not to trespass someone's property, not to enter into someone's property. So these are right in rem. And while right in personam is a duty imposed upon determinate persons. For example, if there is a contract between two persons, so whatever right is related to that contract, that is between the two persons who are party to that contract. Not any third person can come and claim a right on that. But when it comes to right in rem, every person has his right. If my right is infringed by X, Y, or Z, I can I can claim compensation from that X or from that Y or from that Z, whoever breaches my right. So am I clear the difference between right in rem and right in personam? Hello? Hello? Okay. So I presume everyone is uh, like have understood the what is the difference between right in rem and right in personam. Now coming to the next part, the definition, which I already said that we will be dealing with it later on. Fraser's definition: tort is an infringement of right in rem of a private individual giving a right of compensation at the suit of the injured party. So, as in simple terms, tort is the infringement of any person's right by another person, and through which or where because of the infringement the person whose right is hampered has the right to claim compensation from the person who has hampered the right of that person. So now coming to the next is a common definition of tort. See, right now I gave the definitions which were given by eminent jurists, but in exams, although we have to write the definitions given by eminent jurists so as to uh, make our answer more presentable, but in order to remember tort in a very common way, this common definition is going to help you a lot. So according to it, tort is a civil wrong that causes a claimant to suffer loss or harm resulting in legal liability for the person who commits the tortious act. In simple words, tort is a civil wrong through which the person who claims remedy, or who has suffered, he claims from the other person who will be legally liable if he commits the tortious act, right? Or it can also be defined as a wrongful act other than a breach of contract for which relief may be obtained in form of damages or an injunction. So we have discussed about this breach of contract a lot of times, so that a law of tort is different from a breach of contract, or tort is different from contract. So what exactly are the reasons why tort is different from breach of contract, or how tort and contract both are different? So here are the differences between tort and contract. As I already said, in tort the remedy is unliquidated damages, while in contract it's liquidated damages. Then there's the concept of privity of contract, which we everyone knows, which we know that privity contract is that the contract is between two parties and the rights and liabilities are already discussed in that by both the parties, and it is limited to both the parties only. But in law of tort there is no such concept of privity of contract, right? Now, coming to the next is the rights are imposed in tort, the rights are imposed by law, whereas in contract, the rights are imposed by parties to the contract. So, rights imposed by law, as I already when we started, as I already said, that these are the rights which are acquired, or which are, the duties which are affixed by law, or these rights are imposed by law. So that means, for example, we know that it is a right. We everyone has the right to property. We know that if someone infringes the right to property of someone else, or if someone without the permission of the other person enters into his property, that we call as trespassing, which is a tort. So these rights are imposed by law, while when it comes to contract, the rights are imposed by parties to the contract. So as I said, that it is between the parties to the contract. There is no third person in a contract. So that is the difference between tort and contract. So am I clear till now? Or anyone has any doubt, they can ask me. Hello? Any questions? Hello? Okay. So moving forward, now coming to the ingredients of that constitutes tort. As I already said, that there are three ingredients that constitute tort. The three ingredients are the presence of a wrongful act, legal damages, and legal remedy. These three ingredients only define the law of tort, or differentiates tort from any other wrongful act. See, there may be a lot of wrongful acts, but these three ingredients only, when in the presence of these three ingredients only, the tort will be constituted, or the tortious liability will be constituted. The first one, wrongful act. See, as I already stated, that if there is a violation of any of the rights of the plaintiff, by wrongful act doesn't mean an act, it can also be an omission, right? An act or an omission, like act which one should have done, or the act which one should have done but he hasn't done, or he has omitted. So, and that wrongful act has cause the violation of the rights of the plaintiff. For example, everyone has a right to property, right to bodily safety and freedom, right to reputation. And if someone hampers these rights of a person, then or violates, then it will be considered as a wrongful act. So, but as I, hello? Okay. So, but as I already said, that, you know, every wrongful act doesn't amount to tort. So, there are certain exceptions to that, such as social duty or moral duty. Like, for example, let me tell you that if you are going to a club, you are there near a swimming pool, and you see a child is drowning inside the swimming pool, right? So, and you know swimming, so it will be your moral, your social duty to save that child. But if you do not save that child, yes, that will be a wrongful act, morally wrong or socially wrong, but that won't amount to tort, because you, that is your social duty or moral duty. That is not a duty, or that is not an act or right which has been imposed upon you by law. But for example, at the same situation, if you are the bodyguard of that swimming, you are the lifesaver of that swimming pool, or you are responsible for ensuring the safety of the people who are entering the swimming pool, at that time, if you don't help that child out when you see that person drowning or the child drowning, then that will definitely lead to wrongful act amounting to tort, right? So that is the difference. So that is the reason why I said that all wrongful act doesn't amount to tort. Now coming to the next part, legal damages. So what exactly we mean legal damages? So before I explain what legal damages is, I want to mention both the important Latin terms of which are usually, or legal maxims or Latin maxims, which are usually associated or used to define legal damages: injuria sine damnum and damnum sine injuria. So what do we mean by injuria sine damnum and damnum sine injuria? Injuria sine damnum means injury without damages. Here again I would mention that damages means monetary loss or loss of comfort, not personal injury. So injuria sine damnum means there is an injury, but there is no damages. For example, there is a very famous case in law of torts, the Ashby versus White case. So what happened in this case is exactly this, that the person, there was a, in a place, there was elections. So this person was going to cast his vote in the election, but the election officer over that place, he stopped this person from casting his vote. Even if the person had his voter ID card and all the required documents, still he was stopped from casting his vote. And but the problem here was that later on it was found that the person, this person who was about to cast his vote, to the person or the representative to whom he wanted to cast his vote, he won the election. But this person hasn't given his vote because he was stopped by the other person, the election officer. So here the court decided that although there has been no damages to the person or to the plaintiff, like the person, there was no damages, the person to whom he wanted to cast his vote to, he only won the election, but his rights were violated. That there was a wrongful act and his rights were violated. His legal rights were violated because he was not allowed to cast his vote. So he, that's why the court allowed the case of the plaintiff and reward compensated him from the defendant. So that is what we call as injuria sine damnum. Now coming to the next part, the damnum sine injuria. That means damages without any actual injury. This is also a very famous case, the Gloucester Grammar School case. In this case, what happened is that there was a very famous school which was running. Subsequently, another person came and in front of that school built another school, as a result of which there was a lot of loss to the first school, or the school which was already there. So what that person did, he filed claiming compensation against the new school that was built, stating that his rights were his rights were infringed and he incurred damages. So that person, the person who built the new school, he will be liable. But the court held that although there was a monetary loss to the first person, but there was not there wasn't any legal damages to that person. There was no rights of that person was infringed by the other person. This person, the first person, if he had a right to open a school, the second person even had a right to open a school. He's not infringing or getting into the right of the other person. So although that opening of school cost him monetary loss, but there was no infringement of legal rights. So the one of the ingredients to constitute tort was not there. So that's why the court did not grant him any compensation. So from this we learn that in case of tort, it is very much important to have a legal damage. It is secondary whether that damage or the right, or the legal right of the person needs to be infringed in order to constitute tort. If the right of the person is not infringed, then tort cannot be constituted, because it is a very essential element of tort. Irrespective of damages, whether he has undergone any monetary loss or not, that is secondary. The primary important thing is his right must be infringed. Now coming to the third part, the legal remedy. So you must be all aware that about this Latin maxim, ubi justem remedium, which, okay, if you are not, then it means that where there is a right, there is a remedy. So if there is a right, or where if there is a violation of a legal right, then there needs to be a remedy. If there is no remedy, that means there is never a violation of the legal right. And a very beautiful case, this case Ram Gulam versus State of Uttar Pradesh. In this case, what happened was that a theft had stolen some property of a person. Say theft is X and the person is Y. So X stole some property of Y. Then the police recovered those stolen property from X possession. Right? The police recovered those properties from X, the property of Y that were stolen, and police kept it in its custody. Later on, those property went missing from the custody of the police. So in that case, what happened? Y went and filed a case against the state, stating that due to the act of the police, his property were lost. So in this case, the court decided that the person didn't had any right, because so there is no remedy. Why the person didn't had any right? The main reason is being that it was the duty of the police to collect the lost good and keep it in his property, and the police did so. The police performed his duty. He received the stolen property, he kept it in his custody. But then after even taking necessary precautions and everything, the property was stolen. So that is not a duty. So the rights of are not infringed by the police. If the police wouldn't have, even after seeing the stolen property, wouldn't have received it or would have thrown it, then the right of the person would have been of Y would have been infringed, and you could have got compensation under law of tort. So basically, these are the three basic main ingredients to constitute tort: a wrongful act, legal damages, and there must be a legal remedy. Right? So am I clear? Any doubts? Hello? Okay. So coming to the next part, the difference between tort and crime. As I said, the tort is a civil wrong, and wrong there can be a civil wrong. uh, and crime is the public wrong. So the difference, I think in many of the syllabus it's there, the what is the difference between tort and crime. So here it is. So tort is a civil wrong, as I said, and crime is a public wrong. By public wrong, I mean that, see, when tort happens, it doesn't affect everyone. It affects a particular individual. If a person is causing trespassing into the property of a person, then he is infringing the right of just the person in whose property he is trespassing. But when a murder occurs, the entire society is affected. So that is why a crime is a public wrong, while a tort is a civil wrong. Then, so in cases of tort, civil suit is being filed, while in cases of a crime, the criminal prosecution is made. In a case of tort, the complaint is made by the plaintiff or the person whose rights are infringed. We call him a plaintiff. While in case of a crime, for example, let's say murder, the charges are brought by the state. So as I said in tort, now the next point, as I said in tort, the person whose rights are infringed is known as the called as the plaintiff, while the person who infringes the right, he is called as the defendant, who defends the claim of the plaintiff. But in cases of crime, the parties are known as prosecution and accused. Accused is the person who has committed the crime, and prosecution is the state who tries to establish the crime of the accused. And the last one, the remedy is unliquidated damages in cases of tort, while in cases of crime, it can be imprisonment or any other punishment, right? So that's it for the introductory class. I hope you have understood what exactly the law of tort means.